Welcome, everyone, to the Virginia Trial Lawyers Association, the Virginia Employment Lawyers Association, the Metropolitan Washington Employment Lawyers Association's October webinar, What Trial Lawyers Need to Know About Appellate Practice in Virginia. I'm Scott Oswald, and MWELA's Bench Bar Committee Chair and your moderator for today's program. Before we begin, Paul Falabella from the Virginia Employment Lawyers Association and Nick Simopoulos from the Virginia Trial Lawyers Association have introductory remarks for us. First, Paul Falabella from the Virginia Employment Lawyers Association. Paul?
Thanks, Scott. I'm Paul Falabella. I'm a plaintiff's employment lawyer in Richmond with Butler Curwood and the current president of MWELA, which is the Virginia affiliate of NELA, the National Employment Lawyers Association. Our group is lawyers who are primarily focused on plaintiffs' employment work. We've got a really excellent and active listserv that our members have access to. We try to organize CLEs and kind of Zoom meetings like this with MWELA and other groups and on our own. And we're also doing amicus work, including at the Court of Appeals and Supreme Court that we'll talk about some today. And final pitch is we have low annual dues that we're going to start soliciting for here soon. So appreciate you having us and would love for any of you to join. Thanks, Scott.
Well, thank you. Next to Nick Simopoulos from the Virginia Trial Lawyers Association.
Thanks, Scott. Good afternoon, everybody. My name is Nick Simopoulos, and I'm the chair of the Labor and Employment section of the Virginia Trial Lawyers Association. It is a pleasure for me to be here today on behalf of the VTLA, which is co-sponsoring this webinar, along with the Virginia Employment Lawyers Association, and which is put on by Metropolitan Washington Employment Lawyers Association. As far as the VTLA, I do want to take this opportunity just to tell you, for those of you who may not know, a little bit about our organization and what we are. The VTLA is a voluntary bar association dedicated to enhancing the knowledge, skills, and professionalism of trial lawyers, and is committed to improving the law and the fairness of the Virginia system of justice. Statewide, we have about 2,000 members who practice all forms of trial work, including personal injury, family law, workers' compensation, civil rights, and indeed employment. Basically, if you name the practice, we have a member who likely does it. And our mission is three-pronged at the VTLA. It's to nurture a professional, cordial, and powerful community of trial lawyers, to educate trial lawyers, and to advocate in the legislature, judicial forums, and administrative areas for the clients we represent. If any of these missions are important to you, I ask you to check out our website at www.vtla.com and learn some of the perks of membership. Truly co-sponsoring this event is an honor that fits our missions, and we are grateful for this relationship. And I will stop talking now and turn you over to the superstars.
Hey, Nick, thank you. Now to our participants in today's roundtable. Stephen McCullough is a justice on the Supreme Court of Virginia. Prior to joining the Virginia Supreme Court, Justice McCullough served as a judge on the Court of Appeals of Virginia. Before that, Justice McCullough served as the Commonwealth of Virginia's Solicitor General. Michelle Kallen is a partner at the law firm of Jenner & Block. Before that, Michelle, too, served as the Commonwealth of Virginia's Solicitor General. Craig Curwood is a partner at the law firm of Butler Curwood. Craig represents employees in Virginia's trial courts. I'll take your questions throughout the discussion portion of today's program. Just use the Q&A button at the bottom of your Zoom screen. We are going to begin with a primer from Craig Curwood on the Commonwealth of Virginia's 2022 automatic right of appeal in all civil cases. Craig, start us off.
Thank you, Scott. Thank you, everyone, for being here. This is, as you know, what trial lawyers need to know about appellate practice. I am a trial lawyer, as Scott says, and I am a member of all the great organizations that are sponsoring today. And I'm not the one who knows the most about appellate practice. We are so thankful to have Michelle Kallen and Justice McCullough here today. So I will zip through the basics here before, as Nick says, we get to the superstars. All right, so how did we get here? As of 2021, Virginia was without an automatic right of appeal. The Court of Appeals jurisdiction was basically limited to domestic, criminal, and plus some administrative agency and workers' comp appeals. And there was, some robust discussion leading up to what ended up passing effective January 2022. But wanted to share, because a lot of you are probably aware, from the trial lawyer's perspective, there was a split. There are some folks that were very pro automatic right of appeal. Sometimes circuit judges get things wrong, and if your case was wrongly decided, there's very limited chance that you get a writ granted. The Supreme Court can only take so many writs each year. And then there was a lot of trial lawyers who were against the automatic right of appeal, just from a practical standpoint. Adding an extra layer of appeals would lengthen the road to justice. Could potentially slow down the system. And who benefits from that? Generally, moneyed defendants, and not every plaintiff who's harmed, who brings the case is without means, but a lot of us, represent, whether it's personal injury or in the employment context, folks that have less money than the defendants. And so the viewpoint was a longer legal and appeals process gives defendants more leverage to knock down the value of cases. There's a time value of money. Even interestingly, on the General Assembly, even though there's fewer lawyers on the General Assembly these days, the lawyers in the General Assembly were themselves split. But as I mentioned, effective January 1, 2022, it happened, and we are here, and the Court of Appeals expanded from 11 to 17 judges, and now all civil final judgments are appealable as a matter of right. And just before we go to the next slide, 11 to 17 judges, six new judges. To me, that sounds like a lot of work now that every civil judgment is potentially, there's a right of appeal to the extent that they are appealed. Do we have enough judges? I don't know. I don't think I'd want to be a Court of Appeals judge with their workload right now. But we can go to the next slide, Lawrence, and we'll move through some of the statutes and rules in play. Code of Virginia 17.1, 407. Civil appeals are of right from the Circuit Court to the Court of Appeals. And what's not on the slide but should be is 17.1-405A3, which specifies any final judgment, order, or decree of a Circuit Court in a civil matter is what we're talking about. Virginia Code 8.01-670, the appeals from the Court of Appeals to the Supreme Court of Virginia, of course, as you know, are not of right. It is a petition for writ process, similar to how in the prior days you'd petition from the Circuit Court's final judgment, and it's up to the Supreme Court to grant a writ. That's the process of appealing from the Court of Appeals. And we can move to the next slide, Lawrence. 8.01, 675.3. You file the notice of appeal after there's a final judgment in the Circuit Court. You file a notice of appeal within 30 days. Of final judgment. What's not on the slide here, but is of huge importance. Rule 1:1 tells us, speaks to finality of judgments. Rule 1:1b says a judgment, order, or decree is final if it disposes of the entire matter before the court, including all claims and all causes of actions against all parties, gives the relief contemplated, and leaves nothing to be done by the court except the ministerial execution of the court's judgment. Elsewhere in Rule 1:1, it talks about demurs, pleas and bar, motions to strike, and if those are in part sustained and in part overruled. We don't have a final order until everything's all done, until the entire case is disposed of, as mentioned in Part B. So that leaves some practical considerations for us. If we have several claims and we get knocked out on demur, survive on some, but the ones we get knocked out on for some reason are importance to you in your case, and you want to take those up, you can non-suit the remaining claims. So now you have a final judgment that's disposed of for wherever a demur or motion to strike or plain bar was granted. But ultimately, you have to. It's not final until the entire case and all claims and all parties essentially are adjudicated. Rule 5:14 talks about the appeal from the Court of Appeals. Also, again, you file a notice within 30 days, but that leads us to the next slide. Also within 30 days, you have to file your petition for appeal to the Supreme Court of Virginia, and that is your brief. So that's 8.01/671. Rule 5:15A specifies that the Court of Appeals record is the circuit court's record, plus the opinion by the Court of Appeals. Practice pointer that I'm looking forward to hear from our experts is, how it is, number one, the burden to make sure the record is right is on the appellant. So make sure you get the record and get the record complete. All right, next slide, Lawrence. So wanted to just mention a couple from my perspective. What are we as trial lawyers? What are some issues of interest? A lot of us on here are employment lawyers, and as we know, around the same time that the law, that the General Assembly created the automatic right of appeal, there was a slew of new employment laws put on the books. So statutory construction is going to be a huge issue and is going to be of interest to us. I would say B, another issue of interest to me anyway, is what's the proper use of pleas and bar? I don't know about you, but in my practice at the trial level, I'm starting to see some more pleas in bar, and I think we're seeing them on some what would be liability issues. Typically, pleas in bar are to address outside, non-liability issues such as statute of limitations, the workers' comp bar, sovereign immunity. So I think that's at least anecdotally, I'm seeing some more pleas in bar. I would say C, another issue of appeal to all of us as trial lawyers, is any case that could or might infringe on the right to trial by jury or the jury deciding issues. Big news recently on a huge verdict that happened in Richmond. I'm sure there's going to be motions for remittitor. Any time that there's the possibility or action taken by a trial judge to take something out of the hands of a jury are certainly going to be of importance to us. So that's my last slide. Scott, I'll turn it back over to you.
Great, thank you. Well, let's begin the Q&A portion of our program with a discussion of the Virginia Court of Appeals expanded civil jurisdiction. Michelle, I'd like to start with you. On January 1st of 2022, as Craig has described for us, the Virginia General Assembly expanded the Virginia Court of Appeals jurisdiction to become an immediate appellate court for all civil cases. What does this mean from your vantage point for trial lawyers who are trying cases, the results of which could only be appealed by a petition to the Virginia Supreme Court before 2022?
Yeah, so I think there are two ways of looking at it for trial lawyers. One is the reality that if you think something was done wrong at the circuit court level, you will have an opportunity to have that wrong reviewed by an appellate court. So there's the offensive perspective on having an appeal as of right, but there's also a defensive side to it, because even if you think the circuit court has done everything correctly, you also want to make sure that the record is properly developed such that if there's an appeal from the other side, you can properly defend what was done at the circuit court level. So thinking about appeals from both an offensive and a defensive perspective can be very productive for trial lawyers, because the likelihood that now if either side wants to appeal the case, there will be an appellate court reviewing that decision. And so thinking both offensively and defensively is productive.
So now that civil practitioners have the right to appeal to the Virginia Court of Appeals, Michelle, have you seen any trends in the number of petitions for appeal at the Virginia Supreme Court?
So one thing that's been interesting is I think a lot of appellate practitioners were looking forward to see potential difference in the docket at the appellate level. And in some ways, it's been interesting to track that the Supreme Court of Virginia's docket has kind of declined in recent years. There was an expectation that it would potentially increase. I mean, at the Court of Appeals level, the docket has certainly increased, but we haven't seen a commensurate increase at the Supreme Court of Virginia. And for those of us who practice in both federal and state court, folks have noted the decline in the docket at the U.S. Supreme Court level. And we're seeing some of that similarly numerically at the Supreme Court level in Virginia. We would have thought by now, coming up on 3 years in, we would have seen an increase, and that hasn't occurred. But what's interesting is it could be that the court is moving from having both equal roles of lawmaking and error correction to a greater focus on the lawmaking side of the court's role, because the Court of Appeals now is filling the void from an error correction standpoint.
So let's talk a little bit about the Virginia Court of Appeals. The judges hear arguments at courthouses throughout the Commonwealth. Tell us more about this.
Sure. So I think in terms of the way things work from a jurisdictional standpoint and location standpoint, practitioners who focus more at the trial court level will often have cases occur in the jurisdiction or in the location where the dispute is, often where the parties are located. At the appellate level, though, that's more cross-Commonwealth. I mean, the Supreme Court of Virginia has it's the Supreme Court of Virginia where it hears cases, whereas the Court of Appeals can sit in different locations. The Court of Appeals has its own location in Richmond, but then when it sits in other areas in the Commonwealth, it might sometimes kind of take over a courtroom in an area that it traditionally has circuit court proceedings going on, but then the Court of Appeals might come and sit in that location.
So, Michelle, when in relation to your oral argument do you learn the identities of the judges on your merits panel at the Virginia Court of Appeals?
At the Virginia Court of Appeals, it's that morning. Sometimes it's even closer to argument than can be the case in, let's say, the Fourth Circuit. The Fourth Circuit, the time that you learn the identity of the panel is typically on the earlier side in the morning, and you get an email. The Virginia Court of Appeals, it can be up until an hour or so before the argument actually begins. And so preparation for that requires recognizing that any one of the judges on the Court of Appeals could be on your panel.
Michelle, thank you. Justice McCullough, I'd like to bring you in at this point. Now that all civil practitioners have a right of appeal to the Virginia Court of Appeals, has the standard by which the Virginia Supreme Court grants a petition for appeal become more rigorous?
No, and there's no rule or statutory criteria for granting a petition in the Supreme Court of Virginia. Historically, the court has engaged in error correction, which the U.S. Supreme Court has made clear they do not do. And we continue to exercise that function. I think what people should be aware of is, one, our numbers are way down. So the Court of Appeals, with sort of the basic low-hanging error correction fruit, they're plucking those, and typically those are not coming to us. Second, lawyers are expensive. and some folks, either for tactical reasons, they would rather go back to retrial than take the chance at another layer of appeal. Sometimes they run out of money, or they just don't want to spend the money. So the appeal ends at the Court of Appeals. And then you have the phenomenon of if I, as a justice, see a petition on an interesting issue, but you have a unanimous, well-crafted Court of Appeals opinion that I agree with, I don't know that it really makes sense to put the litigants through the expense, heartache, the lawyers who may be on a contingency through another round, when at the end of it, I think the Court of Appeals got it exactly right. So my sense is that the dynamic has altered between the Court of Appeals and the Supreme Court, but the criteria for granting the appeals has not. If there's an error correction case, we think the Court of Appeals was wrong, we'll take it. One final point is, oftentimes circuit courts, all you have is just an order. You don't have a well-reasoned opinion explaining the law. And so I think there was a tendency sometimes to grant the case just to get to the bottom of what happened. It sounds like possibly there's error. Let's just take it and take a closer look. Well, now you have the benefit of a well-crafted opinion, published or not, that really sort of opens your eyes in terms of, okay, well, here's how it's going to be resolved. And I think that has an effect on sometimes persuading us not to take an appeal.
So for those who maybe are thinking about filing a petition for appeal with the Virginia Supreme Court, what are some of the things that they should try to highlight for you to get your attention such that, it might be something that the court would take up?
Right. So number one, obviously, if you think the Court of Appeals was just wrong, then, and I apologize for the background noise, the Court of Appeals was just wrong, that's something that we're certainly open to taking your petition on that. Second, if the case is one of great importance, this is going to set a precedent. It's not just a routine based on application of settled principles kind of case. It's a case of first impression. It's a case that's really going to reverberate over time. It's a case that's going to affect a lot of other things. Those are arguments you can think about bringing that would persuade us to grant your petition.
So let's talk about what happens after the lawyer files the petition for appeal. How are writ panels assigned?
Right. So we have regular writ panels scattered throughout the year. It's a bit peculiar if you're not familiar with it. But the way that works is a panel of 3 or 4 justices gathers in Richmond, and only the appellant is allowed to present oral argument for only 10 minutes as to why the petition should be granted. So it's a good opportunity because if all we have is the papers, we might have questions that we're not able to ask, and you might have persuasive answers to those questions. So it's your opportunity to appear before a panel of justices and explain why we should grant it. It's really short, only 10 minutes. So you need to dive right in with why this is a case that the court should grant, because the Court of Appeals got it wrong, because it's a case of significant importance, worthy of the court's attention, et cetera, et cetera. So definitely take advantage of that opportunity and definitely dive right in when you're there, as opposed to some long explanation of the background of the case, because your time is too precious to get into that level of granular detail.
Michelle.
Yeah, from a practitioner standpoint, 2 things to note on writ panels. One is, if you look at the rules, you'll see that there's an option to have a writ panel or a reply brief. My personal recommendation would be to select the writ panel, and I don't know what the numbers look like, but I would suspect that most practitioners do select the writ panel as opposed to the reply. So that's just something to note if you're looking at the rules, that a reply brief is an option. One other thing to speak to from experience on writ panels as compared to full-fledged oral argument days is the writ panels will often tend to be a little bit less. The justices you can expect them to probably ask some less questions than at oral argument on the merits. I've seen writ panels. I've been on days for writ panels where not a single question was asked. I would suspect if Justice McCullough is on your writ panel, you should expect at least some questions. But it really does depend on the justices, and you can anticipate that it will be relatively less questions than merits arguments. So make sure that you fill all 10 minutes and that you're kind of, you put at the end, if you do get questions, the things that are less important. But I wouldn't anticipate having a very hot bench during writ panels. Thank you.
Justice McCullough, back to you. How are writ panel opinion writing assignments made?
Well, so at the writ panel, it's easy in the sense of all you're deciding is to grant or not grant in whole, grant in part the petition. So for the writ panel, I may not know the ultimate answer yet, but I'm trying to figure out, do I grant this or do I just end it? So in terms of opinion assignments, my court is particular. Some of you may be familiar with a U.S. Supreme Court where the Chief Justice assigns the opinions, or if he's in the minority, the next senior most justice assigns. Our opinion assignments are triggered by slips of paper drawn from a bowler hat. And so it's not based on your expertise or your experience or your desire. It's the hat. The hat has to be with you.
Okay. So talk to us about when you discuss the merits of the appeal with your other colleagues. When does that happen?
Right. So at the petition stage, at the conclusion of the docket, typically on the bench, we simply go back and forth about go down the docket, what to grant and not grant in part, grant in whole. It's a very informal discussion, and all we're deciding is a case move forward or not. So, sometimes it's very minimal discussion because it's an obvious no, there's no reason to grant this. Sometimes very extensive discussion. On the merit side, what we do is at the conclusion of the oral argument, we gather in our conference room. There's an oval conference room. The chief sits at the front of it, and we go around the table expressing our views about affirm, reverse, and the basic reasoning behind that. And sometimes it's fairly minimal because it's clear the trial judge just made a mistake, and it doesn't elicit very extensive discussion. Other times are very difficult to resolve, and so we go round and round, and sometimes it becomes a sort of basically polite free-for-all where we're jumping in and it's less structured. And so that's at least the tentative original resolution, and then we have to go back to our offices and write them up, and then we get comments when we circulate the draft. It's a very laborious process, but appellate decision-making is collaborative, and that's just the nature of the process.
Okay, let's turn to the petition for appeal process, and I'd like to begin with assignments of error. Justice McCullough, you like to say that when a party crafts an assignment of error, the lawyer lays his finger on the error. Tell us about that.
Right, so our rules of court require lawyers to provide assignments of error. In fact, they say if you don't do that, we'll kick you out of court. That is something you need to spend some time thinking about. So if you miss a fact in your statement of facts, that's unlikely to have very broad significance. Maybe you miss a case when you're running your searches. It's unlikely to be the end of your case. If you miss the boat on your assignments of error, that might be the end of the case. So you need to think about that and craft them with some care. So think of the assignments of error as the frame of your case. Whatever falls within that, the court is going to be interested in. Things that fall outside of that, we're not going to worry about. So you have to think about what exactly did the trial court do? What was the ruling? Were there alternative rulings? And you need to challenge each of those. Ideally, what you do is sort of the Goldilocks, not too broad. The trial court erred in admitting evidence. Well, what you need maybe a little more precision than that versus hyper-specific. And then you run the risk that if there's a little more to it than that, and you draw your frame too narrowly, you might be outside of it in terms of where you need to be. So we don't kick that many cases out based on flawed assignments of error, but you do need to think about them, including at the beginning when you're starting to write your brief, but then also at the end, once you're done with all your arguments, make sure everything is encompassed within those assignments of error so that the court can actually resolve your case and not say, well, you're arguing something outside the scope of your assignments of error, and so we're not going to deal with that. Or the court had alternate holdings and you only challenge one of them, so the judgment still stands because there's an independent basis for that judgment. So all that to say, just think with care, take some time to craft those assignments of error so that you can put your case in the right frame.
Michelle, I'm getting anxiety listening to that. I just want to get a sense from you. What's your advice to the trial lawyer in crafting assignments of error?
Sure. So I mean, hearing that, it can be daunting, right? And to respond, one might be tempted to list 15 assignments of error to make sure that you cover the ground and that each one is, perfectly crafted. But if you have 15 assignments of error, that also means that the court is going to expect you to brief all 15, probably within the allotted page limit, word limit. And typically, human attention. I mean, the justices on the Supreme Court of Virginia are extremely smart, but even the smartest among us, loses attention, right? If we're with 15 errors, and one might lose credibility as well, saying, here are all the errors that need to be corrected. So from kind of a Goldilocks perspective and standpoint, you probably want to aim to not have too many assignments of error. If there are multiple errors, you want to definitely preserve them and assure that you've both preserved it and fully briefed it. But at the same time, you don't want to lose attention of your audience. And so aiming to have, between 1 and 3 assignments of error, maybe 4, can then lend itself to a brief that then fleshes out those errors. But you don't want to lose credibility by assigning too many errors. And it also will make it hard for you to be able to kind of get the case reversed, having a clean narrative if you just have too many. Sometimes also when you've seen too many assignments of errors, they repeat themselves. So I think taking the time to make sure that you have the right number and the right structure is really worthwhile.
Justice McCullough.
I think in the typical case, the central issue that you're taking up on appeal is going to be quite clear. You're fighting over statutory interpretation or the application of precedent. And so it's typically not that difficult to come up with a perfectly sound assignment of error. I think that the trick is when the court makes ambiguous pronouncements, and maybe there's multiple hearings, like a motion to reconsider, and the court says something a little bit different. That's when there's a little more of an obstacle to making sure you capture what the error is to bring up on appeal. So I would say in the typical case, it's really a non-issue, but there are those instances when you really have to go to the extra effort of crafting it with care.
So just to put a finer point on it, Michelle, you like to refer to the power of 3. Why is that relevant when thinking about your assignments of error?
Well, I assume what you mean the power of 3 is that the human attention doesn't remember more than 3. And so I think just that's a good metric to use also for oral argument. So if you start an oral argument and say, good morning, Your Honors, and may it please the court, I have 25 points I'd like to raise today. I presume a lot of the justices will not look forward to how you intend to get through all 25 points, but to say, good morning, Your Honors, I have 3 points to make today, that kind of rings, one might look forward to hearing all 3, and you can easily get to all 3 of them. And so I think it's just a basic part of human psychology that the power of 3 tends to be kind of a good place to land. I will say for assignments of error, though, if there is one error that kind of animates the course and the narrative of the case, don't feel forced to have more than one assignment of error. I think having a clear story on appeal is very helpful. And so if part of you is inclined to go towards one assignment of error, I would recommend going there as opposed to three. But in the typical case, more than three assignments of error start to yield diminishing returns.
Justice McCullough, we have a question. At the writ stage, does one justice, two, or three decide whether to grant?
So the rule currently is it takes two to grant, and that holds even on rehearing. So in other words, if you appear before a panel of 3 or 4 justices, it takes 2 to grant. If we turn you down in whole or in part and you ask for reconsideration of that, and so it then goes in front of the entire court, it still takes 2 to grant. Now, beyond that, there's a general collegiality within the court such that I've had many instances where one of my colleagues thought we really should grant something and I was dubious or even against it. And so if they're very insistent, look, I really think we ought to take this, as a courtesy to them, I might say, okay, you've got my vote. That brings us to 2. And part of that is strategic because I may want their vote down the road on something I care about that they may not. And so typically if one is quite insistent that we need to take it, it almost always is in fact granted.
Thank you. Michelle, let's turn to how to properly preserve issues at trial for appeal from Virginia Circuit Courts. You counsel that trial lawyers, they should have a court reporter attend every hearing where there might be something objectionable. Why?
Yeah, so I think having that record is very helpful on appeal. I recognize that can get expensive, and so there are other considerations that practitioners and clients might take into account. But putting aside the cost piece of it, having a record of what occurred below is imperative to putting together the record on appeal, and also to creating credibility such that the courts of appeals will trust what you say. It's a lot more persuasive to be able to quote the court from the record as opposed to setting forth some sort of recollection. I've also seen, this is particularly at the petition for review stage, I've seen cases not get taken up in part because there is no record. And so I think in the event that you think there might be some sort of basis for a petition for review, and for those of folks who are not in Virginia courts all the time, a petition for review is kind of in some ways akin to the Supreme Court's emergency docket. Let's say there's a denial or grant of an injunction and there's a desire to take up an interlocutory appeal. One might seek a petition for review there as opposed to a petition for appeal, which is the traditional way to get an appeal from a final order. But having that record to be able to cite to of the transcript is extremely helpful on appeal, and sometimes the absence of it can be fatal to an appeal.
Michelle, your mantra is, when in doubt, object it out. Why is it important to object to each separate pretrial ruling?
Sure. So I think as a matter of preservation, you should have an objection to the ruling that you object to. From a matter of a perspective of collegiality for the courts, one thought process that might occur at the Court of Appeals level is that the Court of Appeals might be less inclined to reverse a circuit court decision where the circuit court did not have a fair opportunity to actually address the objectionable issue and correct their error. So there's a collegiality element to it. There's obviously the rules piece of it that as a kind of legal matter, absent more extreme circumstances or equitable circumstances they're pretty hard to meet, you need to be to object for it to be kind of appealable and properly raised on appeal. And then I think there's also kind of a matter of appellate hygiene, where it's a lot easier to be able to brief an issue that you've objected to immediately upon it occurring, and even immediately upon it occurring multiple times, because it just creates a much cleaner story to tell, and you're not citing one place of the record for the error that you think occurred and another place in the record for the objection. You're also less likely to get the other side, to elicit the other side contesting whether or not you properly object. And it's typically better on appeal to be able to focus your brief on the merits of your objection as opposed to whether you properly preserved it.
Michelle, we have a question from our audience. What's your view about accepting a continuing objection? if it's offered or asking for one at the trial court. What's your view?
So I think reasonable people can disagree here, but from an appellate standpoint, I still think it looks a lot. It makes writing the appellate brief a lot easier to have the objection immediately upon the issue that you object to. Now, I recognize that circuit court judges might get frustrated if every 10 minutes you say, well, I object, I object, I object. And so, there, I think there's a matter of EQ. If you see that your trial court judge is getting pretty frustrated with you, objecting over and over again, then sure, seek a continuing objection. But from an appellate hygiene perspective, having that objection immediately upon the decision that you disagree with, and that'll be the focus of your appeal, is pretty helpful. And so I think finding that correct balance between preserving the issue at the appellate level and not upsetting the trial court judge, I think there's a careful balance to be had. But from an appellate perspective, I would err on the side of objecting each time the issue comes up.
Michelle, why is it important for a trial lawyer to restate her pretrial objections on the record on the first day of trial?
So I think it's when you're telling a story on appeal, it's helpful to have that objection show up immediately after the area that you're focused on when you're telling that story. In you'll have a fact section of the brief and then a procedural history. And in the procedural history, being able to say the trial court did X and we objected immediately afterwards, it tells a much cleaner story. And then you can also tell the story kind of over and over if that error yielded various problems that you're going to point to on appeal, to be able to point out that you've raised it and you've also given the circuit court the opportunity to correct that error, and the circuit court did not avail itself of that opportunity. A court of appeals might feel more comfortable reversing in that situation.
Michelle, you recommend that a trial lawyer state her objections in writing whenever possible. Why?
Well, first, if there's no transcript, then having it in writing is extremely helpful. And second, written, you have time to kind of craft it very carefully, so then you don't have the or the potential kind of other less, as I'm struggling to speak very clearly right now, that can appear on the record when you're on a transcript. And so having it in written form is a lot prettier to cite back to in an appellate brief, and gives you the time and care to kind of craft the objection in a way that is much cleaner as you tell the story on appeal. It also allows you to have increased credibility, because if you're quoting something that's written, there often may be less confusion about what it is your objection was.
Michelle, thank you. Justice McCullough, what is the difference between error waiver and error forfeiture, and why does it matter?
Generally, it doesn't. I mean, so a waiver is when you formally concede or agree to something. For instance, when you plead guilty, you waive your right to jury trial, and there's a detailed colloquy. A forfeiture is you just are asleep at the switch, you're not paying attention, or it's through inaction or possibly even tactical choice. You don't raise an issue. But so generally speaking, for purposes of issue preservation, doesn't really matter if it's a waiver or a forfeiture. The rules require you to raise an objection to let the trial court and opposing counsel know you have a problem with what's being done, and that will then preserve it for appeal. I will point out there's a statute relative to what Michelle was just talking about, 801-384, that says once you've made an objection, you don't have to keep popping up and saying the same objection over and over again. The only thing you have to be careful with is you have like a conditional ruling. So you come before in a pretrial motion, and the court says, well, I don't know how this is going to play out, so we'll have to wait and see at trial. You don't really have a ruling at that point, and the court is sort of hedging. I think the safe thing to do in that circumstance, even though you had a pretrial motion and argument, is at that point to object and say, well, remember pretrial, you weren't willing to rule, but I want to make it clear, that expert shouldn't testify, that jury instruction shouldn't be given, or whatever it is, to be on the safe side, notwithstanding that statute. the statute is there, it can help you, but to avoid just this sort of repetition that irritates the court. But there are situations where the safe thing to do is to renew it.
Michelle, Justice McCullough mentioned objecting to jury instructions. When should the trial lawyer object to the trial court's jury instructions?
Yeah, so I recognize that some practitioners might disagree, but I err on the side of doing it more. And now that's all to say, most of my work in Virginia has been at the appellate level, not at the trial level. So I haven't incurred as much of the wrath of a circuit court judge who's frustrated with having too many objections. But with that noted, I think doing it as many times, or doing it as often as the issue comes up, from an appellate standpoint, just makes it easier to be able to tell the story of, this error happened, and here's kind of the story of how it played out. So I think the earliest opportunity you have, I think also from kind of an equity standpoint, doing it as early as possible so that the circuit court has the opportunity to correct the error earlier, and then that error doesn't kind of play out over the course of a trial, is really prudent. So from the moment you think something objectionable is happening, raising it and giving that opportunity to correct the error, the circuit court might agree with you and then might correct it, and then the other side might be the side that needs to object. So I think, again, when in doubt, object earlier if possible.
Justice McCullough.
Just real quick on the point of jury instructions, make sure those are in the record, whether read or the actual paper instruction, because we've had a number of cases where it was clear there was some issue with jury instructions, but without the benefit of the actual instruction, it's hard to know whether it was error or the error mattered. And it's just a basic preservation point to proffer, whether it's the instruction, the witness, or whatever. That's kind of a defensive tactic to preserve appellate reviews, make sure that proffer is in there.
And Michelle, should a trial lawyer object when a trial court gives the instruction to the jury, even though the trial lawyer has previously objected at the jury charge conference?
I think there it really depends on the situation. If there's a tactful way, yes, as long as you've kind of fully preserved it. But I also recognize you might incur the wrath of a trial court judge by over objecting. So I think if there's a tactful way to do it, yes, but I recognize that other folks might disagree with me here.
Michelle, thank you. Craig, I'd like to bring you into the conversation. Give us just a preview of what you think about when you're considering whether to bring a case in Virginia Circuit Court versus federal district court. Give us a sense of your thought process.
Sure. Yeah, like Michelle said, she does both federal and state. I do, and those of us who do a fair bit of employment do both federal and state. I will piggyback off real quick on the objecting and the jury instructions. Yeah, as the trial lawyer, I don't want to incur the wrath of the circuit judge. I've made my objections outside the presence of the jury, submitted my proposed and denied instructions, objected to whatever's been submitted. I'm not gonna stand in the way of the circuit judge with an objection, but that's my preference on that. Hey, as far as a client comes into my office and there's a potential to bring a state claim or a federal claim, I look at a couple of things. Number one, you have to analyze the specific state versus federal laws in play. If you're looking at a discrimination case, in the federal side, Title VII has caps on damages. On the state side, there is no caps on damages under the Virginia Human Rights Act. On the federal side, summary judgment is cases are federal cases, and the Fourth Circuit are littered with summary judgments granted in favor of the defendant. And in state court, you are much more likely to get to a jury. based not only on what our Constitution says, as I referenced earlier, but the directive generally of the courts, the Supreme Court has been, if it's a question of fact, let it go to a jury. We have a rule in Virginia of summary judgment, but we're by statute, we're not allowed to use depositions or affidavits. So those certainly are factors. I'm in Richmond. We're in the Rocket docket here in the Eastern District of Virginia, and the speed of going to trial in federal court versus the state court. All of those considerations are things that I look at in deciding where we're going to end up filing.
How about voir dire? How is that different in the U.S. District Court for the Eastern District of Virginia versus Virginia Circuit Court?
Simple. Federal courts, you don't ask the question, the judges do. You submit it in writing, and the judge decides what she or he is going to ask. In circuit court, the trial lawyers get up and for both parties and conduct a voir dire.
How do you approach when you have the opportunity to participate in attorney-led voir dire? How do you approach that in Virginia circuit courts when you get, let's say, an employment client?
Yeah, I mean, like Michelle said about, and the justice said about thinking carefully about assignments of error. Think really carefully about voir dire. I mean, it's the first opportunity as the lawyer to get up and address the people who are going to be deciding the issues. So you need to be really mindful of the questions you want to ask, and to the extent that you can get your client's viewpoint and your theme and theory of the case inflected through the questions that you're asking. That's what you want to do, because as trial lawyers, we're persuading every opportunity.
Let's turn to tips for briefing at the Virginia Supreme Court. Justice McCullough, from your perspective, what are the attributes of a well-written opening brief?
Yeah, I don't think there's any secret sauce. I mean, anyone who with a law degree can write a good brief. And there are people with exceptional talent, but the reality is anyone can write a good brief. So one, check the rules. Make sure you have everything in there that the rules require, because you don't want to waste your time with a redo or whatever. So for example, our rules say with your assignments of error, you have to point to where in the record the issue was preserved. Just make sure you do that so you don't get a nasty gram from our clerk's office saying, hey, your brief's incomplete, you need to do it over. So check the rules. Make sure you give yourself the time to write. There's no such thing as good writing, only good rewriting. And it takes time to sort of work your statement of facts to come up with a persuasive story. Don't just do witness A said this, witness B said that, witness C said that. That's terrible. You're storytellers, you're trial lawyers, you're good at that. So tell the story in the statement of facts in a way that's most persuasive. And then make sure you give yourself the time to do the proper research and organization. And so, a well-crafted brief is thorough. It omits extraneous stuff that's not relevant to the issues on appeal. So it's thorough. It doesn't have stuff we don't need. It's well organized. It's thoroughly supported. Please give us citations to the record, particularly in a voluminous case, so we can, as Ronald Reagan said, trust but verify. So we can go then into the record and see. Spend time on your assignments of error to get those right. And also spend time thinking about what relief you want. Do you want a new trial? Do you want a reverse and final judgment? And feel comfortable asking for relief in the alternative. I'd like a new trial, but failing that, I want this or whatever. The bottom line is all this is quite doable. And also, please don't, you may really not like your trial judge. You may really not like opposing counsel, but we're not there to referee that. It's not a likability contest. So forget all the ad hominems, even if they're well-deserved. And sometimes they are. Keep all that out. Keep it clinical, and you'll be in good shape.
Justice McCullough, is identifying the standard of review important in the opening brief?
It is. I mean, the rules require it. And so standard of review comes into play, one, with issue selection, because you might have a great trial issue that's a lousy issue on appeal. So you might have witnesses you think are persuasive, but the jury didn't buy it. Well, the appellate court's not going to touch that. Or admitting evidence. You might have a real live issue to get the court to exclude evidence or admit evidence, but on appeal, that's viewed through a deferential lens. And so think about when you're picking your issues for appeal, what is the standard of review? That's the terrain on which you fight, and you want to pick favorable terrain. The other thing to do is don't just cite it and then ignore it. It has to factor into how you write your argument. So if it's an abuse of discretion, explain to us why it's an abuse of discretion, don't just sort of cite it and forget it. But also defensively, it can be an asset for you. So if your opposing counsel, you're defending your win, has picked an issue where the standard of review favors you, well, then absolutely bang that drum and use that in your favor. Many, many times the assignment of error is easy, it's clear, there's a whole bunch of cases that tell you what it is. But you have to pay attention to those few instances where it's up for grabs and then fight like crazy to maneuver it onto a favorable assignment of error. So it's not clear. Is this really abuse of discretion? Is this really de novo? Sort of be creative sometimes about trying to push the court onto favorable terrain to help your side of the case.
Michelle.
Yeah, I think two things on standard of review. First, if the standard of review is in your favor, remind the court of that. I mean, section headings are a great opportunity to say over and over again, the circuit court did not abuse its discretion in doing X. The circuit court did not abuse its discretion in doing Y. And then end each section by saying, even if in the first instance, a de novo court might disagree here, it surely does not rise to the level of an abuse of discretion. And so you can even write your brief by saying it too much and cut back a little bit. But I've seen a lot of briefs that have a favorable standard of review that kind of allow the argument to be essentially on de novo grounds when they should be on higher, grounds that are more favorable. So erring on the side of reminding the court that the standard of review is in your favor is a prudent thing to do. And section headings and conclusions are a great place to do that. The flip side is if you have a bad standard of review, you shouldn't completely ignore it or entirely shy away from it. You want to, if you can shift it on more favorable grounds, if there's some basis to have a better standard of review, definitely raise that. But then also persuade the court why, even if on the grounds of the less favorable standard of review, you should still win. And so they're looking for cases where that court or a higher court has reversed or affirmed on that standard of review that's not favorable to you, but someone else in your similar position has won. And perhaps at the ending of a section or as you're analyzing to say, look, this isn't so crazy for the court to hold that there has been an abuse of discretion here. In fact, no less than on 3 prior occasions in the last 5 years, this court has held that there's been an abuse of discretion, and our situation is similar to that. So owning the standard of review and persuading the court under the standard that the court is reviewing is very important.
We have a few questions from the audience. Justice McCullough, what makes a strong and persuasive amicus brief?
So those are great, particularly when it's a case of first impression, an area the court hasn't seen a lot of. So, an amicus brief by a subject matter expert that can really help us, one, at the petition stage, see the importance of a case. This really matters to an industry, to a group of lawyers, to a group of employees or whatever. This is a significant case. So you send that signal when you come along with an amicus brief that this is a big deal case. You really need to take it. So that's one thing. The other is to help the court understand how a statutory scheme fits together. So maybe we're right here in this specific subpart of the statute, but there's an overall statutory scheme the court needs to understand. And you're the subject matter experts. And so it's an opportunity to educate the court about how the law works If you pull on this string, here's what you're going to unravel over here. If you don't mess with that, it's a good thing for these reasons. So you have all this expertise and this practical knowledge that the court may not have because the law is vast and we're in an age of specialization. So an amicus brief can serve all those purposes at the petition stage and then at the merit stage to help us understand the implication of what we're doing and the best path to resolve a case.
Michelle, in divorce cases, a circuit court judge can make different errors on types of error and types of errors concerning many different types of issues. Do we focus on our strongest assignments, and still limit the number of assignments of error, even if the issues are quite different from our audience? What do you have to say about that?
Yeah, so I think it's a matter of trying to, if you can categorize the errors in a way that captures not too many assignments of error. I'll admit that I'm not very familiar with the divorce and family law circumstance, but if you can categorize it as, it was an error in terms of the standard that the court was applying, or it was an error that kind of fits within a certain category, I would still recommend kind of getting the errors to aim for around 3 or so, just even for the practical reason that it's really difficult to fully brief so many errors. And so I think if you can lump them into categories, that's easy for a person to follow. I still recommend trying to do that.
Michelle, what's the most important part of the opening brief to you?
So, I think from a perspective of Virginia appellate courts, the most important part of a brief is an assignment of error, because you can kind of fully win or lose. But putting that section aside, I think it's the summary of the argument. I think if someone has very limited time and wants to know what the case is about, they very well could pick up the brief, and that might be the only part that they read. And so I think being able to capture your points and your story in that section is extremely important.
Justin McCullough, when should lawyers craft their summary of argument in the brief writing process from your vantage point?
I did that last when I was handling appeals, because you're playing with your organization, trying to figure out which arguments are creative, insightful versus a little too creative and off the reservation or whatever. And so it's really when you get to that final, you're pretty comfortable with your organization and your key points in your theme, that's when you do that. So I did that last when I was writing the brief. And I agree with Michelle, it is an important thing because you typically you're there to argue one case. We might have multiple days of argument. And so, of course, we're going to go through your briefs. We're going to study them. We're going to read the authorities you give us. But then, the night before the writ panel, the night before the argument, we might do a quick run through. And that summary is really helpful to refresh us what we might have looked at, several weeks in the past.
Justin McCullough, what do you wish you saw more of in opening briefs?
I think we get a wide range of advocacy from supremely talented lawyers who are excellent writers to sort of a beleaguered, lawyer who's a little out of their zone of expertise on appeal. I think the bottom line is, one, particularly on complicated cases, having lawyers who can educate us on some of the complexities of environmental law or a particular regulatory scheme, stay away from the blizzard of acronyms. Those can be obstacles to understanding. Those are some things that are helpful. And also, particularly on a case of first impression, persuasive authority, whether it's there's all kinds of smart judges out there, smart academics. So on a novel issue that we may not have dealt with before, to really take the time to educate us, as opposed to statute says this, court was wrong, understand how everything fits together, to me is helpful.
Let's talk about the opposing brief for a minute, Justin McCullough. You counsel that in writing that brief, you shouldn't be limited by the organization of your opponent. Tell us about that.
Yeah, no, I think you should lead from strength. And so, your opposing counsel might be downplaying some of the issues they might have, such as preservation, and tout the significance of this case or whatever. Well, your best argument might be, well, you might need to reach that issue someday, but this was not preserved, and here's why, and so you just need to get rid of this case. Or, well, even if there was error, let's just assume that for a moment. Look at all the evidence that came in. It was obviously harmless. And so my recommendation is lead from strength as opposed to sort of matching your arguments to the organization that your opponent adopted. So, think about things like preservation, harmless error, or whatever else that might be your best friend, and then preserve your win that way.
Michelle, when, if ever, should a party waive their right to file a reply brief?
Well, my recommendation is that at the writ stage, waive filing a reply brief in favor of argument before a writ panel. I can't think of a reason to waive a reply brief at the merit stage. I mean, you could potentially have a reply brief that's very, very short. And I can envision circumstances where one might not want rebuttal time. I mean, it's very limited, but it can have a very impactful response to not have rebuttal. I can imagine circumstances where that would potentially be appropriate, but they're very limited. I honestly can't imagine one where it makes sense to waive a reply brief, maybe err in favor of one that's short because there isn't a ton to say. But it's very rare that there's ever nothing to be said in response, even if it's a matter of kind of correcting what's in the record or correcting a standard or correcting a representation of a case. But I'd be curious if others have encountered situations where it would have been very persuasive to not have a reply brief.
Justice McCullough, does it surprise you when you don't get a reply brief?
It doesn't surprise me anymore because it often happens that we don't have a reply brief, but I'm not sure why. Because, I mean, imagine you're in front of a jury. Why would you resist the opportunity to have the last word? The only time I can think about it is if you have just an absolute slam dunk error correction. I mean, it's obvious. Here's the recent right on point case, and your opponent's brief doesn't really do much. They sort of kick up some dust to try, but it's obvious there was error. Then maybe you say, well, for the sake of brevity, I'm going to waive the reply brief. But that's almost never. So I'm surprised how often we don't see one because it really is your chance. And what I've heard from some lawyers is, keep your powder dry for the oral argument so you can spring it, on opposing counsel. But oral argument is so short, and you may not have that opportunity. You may be bombarded with questions, and so that powder you kept dry, you never get to use it. So put it in the reply brief. I think that's 99.9% of the time, that's the smart play.
Michelle?
Yeah, the other thing to think about is if you're saving something that you're going to spring on your opponent at oral argument, you might also be springing it on the court. And so having an opportunity, thinking about your audience as the court, rather than thinking about writing the brief to trick your opponent or beat your opponent, at least from my perspective, I view the exercise as one very much geared towards the court as opposed to gearing towards having a one-up on opposing counsel.
Justice McCullough, is there a procedure to notify the justices of new authority after the briefs are filed?
Right. We now have a rule of court that parallels the federal Rule 28J. It's Rule 5.6, or 5.6a, where it just tells you how to do that. And so what you want to do is not just spring it at oral argument because you might run into trouble, is alert the court to it, send it to us, and then send it to opposing counsel. And then we have the benefit of that. So there is a procedure in the rules for that to happen, and it can be a very helpful thing to have.
Let's turn to oral argument. And Justice McCullough, just tell us a little bit about the run-up to oral argument. How do your clerks and staff help you prepare for oral argument?
Well, so when we get the docket, I sit down with my clerks and we go over the docket case by case. figure out, what we think the answer is. Are there areas that possibly we could ask counsel about? And so, one of the things we have to be mindful of is once we decide a case, it might set a precedent for 100 years. It might have implications in other areas of the law. And so we want to make sure we make the best decision. And so occasionally those discussions will lead to, I'll take some notes and but I do not ask my clerks for a list of oral argument questions. But those discussions prior to the oral argument can generate, the need for more elucidation by counsel.
Justice McCullough, what advice do you have for lawyers at oral argument?
I mean, obviously preparation is key. You have to think your case through and what you're prepared to concede and what you're prepared to go to battle on and not give up on. So preparation, refresh yourself on the key facts in the record, on the key cases. Moot courts can be helpful in terms of anticipating questions and the best answer to those questions, particularly in a significant case. If it's a routine case and you're an experienced lawyer, it may not be that helpful. But really preparation, and then everybody has a different style. Everybody has a different sort of set of tools that they use. When I was handling appeals as a lawyer, I would have a notepad with 2 or 3 key points that I absolutely wanted to get in. And maybe below that, key places in the record and key cases. In the event I froze or whatever, I would have that right there. And so it's really about half a sheet on a legal pad of the key things I wanted to get out. But others have note cards, they have iPads, whatever works for you in terms of, and then typically the court will give you a minute or 2 of uninterrupted time. And so use that wisely to dive in to your key points as opposed to some long background about what the case is and what happened at trial. You need to jump in, like cannonball in at the deep end with your key points, because that's the time that you're most likely to have no interruptions. And one final point, if you're defending your win, be flexible, because you may think your key argument is A, but you just witnessed your opposing counsel get beat up on B. So be prepared to reshuffle your deck and jump on B. And well, as the court has recognized, is obviously the case turns on B, and here's why I win. So be prepared for to be flexible as the appellate.
Michelle?
Yeah, so this is the unique opportunity where I actually physically have an example of what I bring up to the bench, or what I bring up for oral argument, because I have a weird system. And so if I can infect anyone with this process, I'm happy to show. So I bring up a manila folder like this, and then inside of it, I have like a piece of paper that will, this one's empty, but it'll say like the 3 points that I plan to make. I'll put notes in there of answering the judges or justices' questions. But then I have this folder that has in it, I kind of glue note cards that have the standard of review or key cases, and then I can flip it in response to the judges or justices' questions. And under each note card, we'll have the locations in the record or quotes from a case. And so it's a way to get a lot of information up in a very small system, because I find that if I try to take a binder up that has all the briefs or just a lot of stuff, it makes this setup really difficult. And if you get up to the podium and your setup is difficult, it can be that much harder to kind of glide in gracefully to your argument. So I think my system's a little bit weird with the note cards glued on or taped onto a manila folder, but it's been really, really helpful for me. Particularly, there have been instances where it's like there's a specific record citation or a specific quote. I can get a lot of information readily available there in a way that doesn't look like I'm taking up too much to the podium.
Michelle, that's terrific. That's worth the price of admission. Thank you. Justice McCullough, we have a question from the audience. How often does oral argument actually change your mind on a case?
I've heard the figure 15% of the time. I don't know if it's hard to say. Oral argument is very helpful, though. It's helpful for us in terms of figuring out the right path to take. Do we go in this direction? Do we go in that direction? I would say when it's a type of issue we haven't seen a lot. So, on a Fourth Amendment issue, I did a lot of that as a lawyer. So I have a lot of background knowledge and experience. But let's say you have some banking statute that I've never seen before. I don't have any idea it's even out there. And you're trying to persuade me you should interpret the law this way. And so I'm coming at it sort of fresh eyes. And so on those, if the statute's really sort of opaque or whatever, it can make a huge difference because I'll read the briefs and think, well, both sides make good points and maybe I lean in this direction. And so there are certain kinds of cases where the oral argument is absolutely the deciding factor. And then other kinds of cases where you could be the most charismatic, prepared, amazing lawyer, and it makes no difference whatsoever because the facts are what they are and the law is what it is. And it's really, so there's a huge range in there.
Justice McCullough, is the justice assigned to write the brief generally the justice asking the most pointed questions at oral argument?
That is often the rule of thumb. So you're trying to figure out who's got my opinion assignment going into the argument. Often, the judge or justice who asks the most questions is the one who has the assignment. But I have some colleagues who are very active questioners, or someone just takes an interest in the case and they're asking a lot of questions. And then I have some colleagues, even when they have the assignment, they tend not to ask a lot of questions. So that is a correct rule of thumb, but you can't take it to the bank.
How often does the justice who's pre-assigned to write the opinion not end up writing the opinion?
It's fairly rare, but if they're in dissent or they're just not comfortable with a resolution the court is proposing, they will then turn it over to a colleague who volunteers to write. Maybe 1 in 20, something like that. That's just a rough estimate. So oftentimes, and the ethic is you got the assignment, your job is to write it. So there have been situations where the person who had the assignment wrote it and then wrote a dissent and then asked someone else to stick their name on the opinion that they wrote. I don't think that's the best way to go, but there has been precedent in that direction.
Justice McCullough, you talked about ad hominem attacks. Let's talk about the opposite of that. As you read briefs or listen to oral argument, do acts of civility and professionalism from lawyers have an impact on you and other justices?
I mean, there's so much contention in the law. People want to take someone else's money, or they want to take their kids, or they want to whatever. So there's that friction. And civility is sort of the lubricant that keeps the machine working. And so it impresses us when we see lawyers acting professionally, and look, if the opposing counsel's ridiculous, we will see that in the record. We don't need you to get the megaphone and shout that. Or if the judge did something crazy, that'll be apparent. So we very much appreciate civility, courtesy, professionalism. It helps us focus on the issues that matter instead of this sideshow.
Michelle?
Yeah, so I think we have a lot of Virginia practitioners here, but one of my favorite things about practicing in Virginia courts is the importance of civility. And that's something that's particularly special in Virginia. That's not to say that other courts don't value that. I think they all do. And I think it's prudent for all of us to maintain that in any area of practice. But this court in particular, and I'd say especially the Virginia Supreme Court, truly values civility and lives up to that. And it's something that's just part of the culture of the Virginia Appellate Bar and is one of the many special things about practicing in that community. And so I would say that when in doubt, be as civil as possible, because that is just part of the culture of the Virginia Appellate Bar.
Justice McCullough, I'd like to just spend just a moment on your road to the bench. We've got a number of practitioners who would like to potentially take the bench at some point, and tell us about your road to the bench.
No, there's no one road, but if you are interested in becoming a judge, Virginia is very peculiar because the General Assembly selects judges. So many states elect their judges, and there's different formats for that. Of course, the federal model is the president appoints and the Senate confirms. Virginia, the legislature has the power. So it helps if you have a good reputation as a lawyer, but fundamentally, you have to cultivate in any of those models, but you have to cultivate a political support and connection if you're interested in being a judge. So for me, I never expected to be a judge. I grew up in a blue collar neighborhood and overseas on top of that. So I didn't, moved to Virginia as a college student. But so one of my roles was giving legal advice to the General Assembly on different things. And I think sort of fortuitously that probably helped me when I put in for a judgeship, because a lot of them happen to know me. Now that can be a double-edged sword because the client doesn't always want to hear your legal advice. But at any rate, so that's just a one thing to think about beyond making sure you have a sterling reputation for integrity and ability or whatever. So I handled appellate cases at all levels, and then it really is a time and chance kind of thing. I mean, Justice Alito said, if you want to be a judge, it's like go into the field with a metal rod during a lightning storm, and you can do everything right, but it doesn't mean lightning will strike. And so the stars aligned for me. But and luck favors the prepared. So maybe you can do certain things that put you in the best position when the time comes.
Michelle, what advice do you have for less seasoned appellate lawyers looking to make a career of appellate work?
Sure. So I think one avenue that's both really valuable in the Virginia bar and does good in the world, but also can give you opportunities to strengthen your appellate chops is taking on pro bono opportunities. There is need throughout the Commonwealth to take on matters pro bono. And you can really help make a difference in people's lives doing that. And also that can give you an opportunity to write briefs and argue. I think also not thinking both of merits cases, but also thinking about pro bono representation at the writ stage. From what I've seen, there's always a need for that kind of support. And Virginia is unique in that you can get to have an argument even at the writ stage. And so if you are interested, reach out. I think there are formal pro bono programs to sign up for, but if you're in doubt, feel free to just call the clerk's office and say, I'd really like to take on pro bono opportunities. I'm open both to merits matters, but also take on writ opportunity. And I would suspect that pretty quickly you'd have an opportunity to both brief and argue and do some good. So that's a great way to get your appellate chops and get started.
Craig, what do you love about practicing in Virginia state courts?
Two things come to mind. Number one, the civility and professionalism that Michelle and Justice McCullough referred to. As everyone knows who's admitted to the Virginia State Bar, it's a requirement to go through the Justice Carrico professionalism course. And that was the first course of its kind in the country, and many other states have followed our lead in requiring that type of course. Number two, I love our right to a jury trial here in Virginia. The Supreme Court has said in the context of analyzing our Virginia Constitution that there are and may be aspects of our Constitution that rights are even stronger than that found in the U.S. Constitution. And I don't know how many other constitutions use the word sacred to describe the right to trial by jury, but Virginia's does.
We are ready for final thoughts. And Michelle, I'd like to begin with you. Final thoughts.
Sure. So I think echoing just really genuinely, I love practicing law in Virginia, and I can't think of a better place to do it. People are really kind. The judges and justices are so sophisticated, and the work is fascinating and interesting. And so I think whenever practicing and the ins and outs in every case can get difficult and complicated, but I think maintaining that perspective really is helpful. And so that's just a final thought that comes to mind with everyone here. and it's fun. I mean, if you follow what you enjoy doing and you connect up with people who are great, if you're a trial lawyer and you have any questions, reach out to folks in the Virginia bar, or the Virginia Appellate bar. I'm available. I've had folks just randomly call and ask a question, and I'll help if I can. And so I think remembering that we have this really wonderful community, and if when in doubt, reach out to that community with basic questions. I think if you are kind to people and you endeavor to help other people, you'll find that people do the same. And the appellate bar in particular is a really special place to do that.
Justice McCullough.
Yeah, I think the reform of the Court of Appeals was a really good reform in the sense that it gives you that appeal of right. You don't have to ask, and if it's an issue that's not completely frivolous, you will get your opportunity to stand in front of a panel of judges and shape the law. In appellate cases, I talk to lawyers. For a lot of them, it's really gratifying to have that opportunity to set a precedent that's going to be there for a long time and to really shape the law. I know a lot of cases settle. I know clients don't always want to pull the trigger on an appeal, but I think that reform was really helpful in terms of developing Virginia law. And then finally, I love my job. I love the opportunity to work on these significant issues. I'm thrilled when I get a meaty, important, consequential case. And so, bring the appeals. I'd rather do that than not. And so don't hesitate if you think you have a good case to bring it.
Greg.
I'll harken back to just about 30 minutes ago when Justice McCullough said, hey, we see really seasoned lawyers, and then we see beleaguered lawyers out of their comfort zone on appeal. And be honest in the audience, how many of us trial lawyers were thinking, I could see myself as that beleaguered lawyer out of comfort zone on appeal? So my parting thought is, piggybacking off what Michelle also said, is not just to reach out to her. I've had the pleasure of working with Michelle. She's among the best of the best. We as trial lawyers have, can and should reach out to and co-counsel with or hire appellate lawyers to the extent we have important meaty issues that need to go up. And in addition to Michelle, we at the VTLA and MWELA have really smart, good appellate lawyers you could reach out to, like Steve Emmert and John Davidson. So that is my parting shot, is that now that our cases are automatically eligible for appeal, let's get to know our appellate brethren.
Paul.
Thanks so much to the excellent panel. It was really insightful. Craig mentioned kind of this slew of Virginia employment laws that went into effect in 2020 and 2021. And if you've been to a conference since, you're often hearing like, where are all the decisions? Where is this tsunami of cases? And I think in part the answer is it's going to be at the Court of Appeals and the Supreme Court, because so often we're getting kind of not reasoned opinions at the circuit court level. So I might have a great opinion, but I can't really use it anywhere else. It's going to take the work at the Court of Appeals and Supreme Court. So these insight is really important.
Well, thank you. Nick.
Yeah, and I want to thank this excellent panel as well. And my final thought is, this appellate practice, it's here, it's real. I've clerked for the Court of Appeals. I've been there over the last year. And the piece of advice I have is know thy rules, because read them, reread them as many times as you need to in a case, because they're highly technical. And the last thing you want is to have a case dismissed because you didn't follow those rules. And one last point is, you never get to the Supreme Court of Virginia if you can't get through the Court of Appeals.
Nick, thank you. Thanks to Justice Stephen McCullough, to Michelle Kallen, and a special thanks to Craig Curwood, who organized this webinar for us. Thank you too to Paul Falabella, Nick Simopoulos, and our co-sponsors for today's program, the Virginia Employment Lawyers Association and the Virginia Trial Lawyers Association. Mark your calendars for the Metropolitan Washington Employment Lawyers Association's next webinar on November, in particular on November 7th. And we will be discussing the District of Columbia Human Rights Act in 2024, featuring DC Superior Court Judge Neil Kravitz. For all of our programming from the Metropolitan Washington Employment Lawyers Association, You can find us at www.mwela.org. Thanks for joining us today.